Welcome along to the first in a series of training sessions in 2026 that we're calling the IUA's Underwriting Essentials series. These training sessions will explore fundamental concepts relevant to practitioners across all classes of business. My name's Tom Hughes. I'm the Director of Underwriting at the IUA. In case you haven't come across the IUA before, we are the trade association for the company market in London. We represent around 80 insurers and reinsurers. And in my role, I work with the IUA's newly formed CUO Council, our long-standing clauses committee, and our various underwriting groups, bringing together practitioners across all classes of business. So very much looking forward to the session today. And this first session will tackle the general underwriters agreement, considering the roles of leaders and followers in the subscription market. Now, as we work through the session, you'll have the opportunity to respond to some polls. So please do take the opportunity to get involved at those moments. And we will set aside some time for questions at the end of the session, but I'll monitor those as we go through and interrupt our speaker at the appropriate time to pass on those questions. Hopefully you've spotted the Q&A function in the platform. Just have a look around it and it should jump out to you. And just to let you know, we will be circulating the slides from the session and a recording will be posted on the IUA's YouTube channel in case you haven't come across that yet. Worth checking it out. Lots of similar sessions on there. Now, to lead this first session in the Underwriting Essentials series, we've secured the expertise of Andrew Schutte, Partner, Head of Reinsurance at Keoghs. Now, something you might not know about Andrew, perhaps a fun fact to share, is that he's a lepidopterist. And perhaps that could be the subject of the first poll, Andrew, because there'll be a few people like I was Googling exactly what that was. But that's everything from me. Really looking forward to hearing a little more about this subject. And Andrew, with my thanks, I'll pass on to you.
Thank you, Tom. Good morning, everybody. Thanks to Tom and the IUA for inviting me to talk on leaders and followers, a user's guide to the subscription market. Hopefully you can all see the screen. Hopefully you can hear me. Any problems with that, put it in the chat. Tom might be able to help you. So let's see if we can move these slides. Oh, there we go. So that's me with a bit more hair. I have been in this market for 25 years as a coverage and wordings lawyer, and this is slightly shorter than usual version of a session I've been doing for 15 years on leaders and followers. Anyone who's interested in the longer version on an in-house basis, then do let me know. I'm sure many of you will have seen a version of this before. I seem to have been doing it for a very long time. What this session is not, before we get stuck in, is it's not a session about reinsurance follow settlements clauses. It's not a session about follow the fortunes clauses. It's not a session about delegated authority agreements. And it's not a session about lead manufacturers under the recent FCA policy statement. Those are all things I talk about, but I'm not going to talk about them today. I'm also going to ask you to join me on a little side mission today, which is unrelated to the subject matter, and that is to discourage unauthorized selfies on my phone. I get hundreds of these. I don't know if anyone else has ever had the same experience, but I'm going to discourage them today by sharing a few of those selfies with you. You today are very important adults. So thank you very much for your part in this important work. There you go. This is gigabyte upon gigabyte of this stuff I get. So I'm sharing it. I'm sharing it with you. Hopefully it'll have a deterrent effect. I don't have very much hope. Anyway, let's get back to the subject matter. So what we're really going to talk about today is the subscription agreement in the market reform contract. And if you look at that, the first thing to say is that it does two different things when it comes to lead and follow. There are two different regimes, one for underwriting and one for claims. They're all in the same part of the contract, but they are separate and they do not work in the same way. Just because, for example, you're a claims agreement party does not mean that you have particular status when it comes to being an agreement party for contract changes. They are two different things. So we're going to look at them separately. We'll also do a little bit of jargon busting before we begin. We need to know, I guess, for this session, what a contract leader is. I've got a quote here for the MRC 3.0 guidance. I'm not going to talk very much about MRC 3.0, which is the most recent iteration of the standard form contract that's used in this market, the market reform contract, because I don't come across it very often, certainly not yet. But it does have some good stuff in the guidance about what different words mean. And so this is what a contract leader is. Now, they do also in the same guidance, I think a little bit optimistically, indicate that we should no longer be referring to slip leader. But that, I think, will be a very stubborn term. And I'm myself still using slip leader quite a bit. But anyway, contract leader. Who's the contract leader? It's the lead as shown in the subscription agreement on the slip. It's normally the insurer with the largest participation in the risk, but not necessarily. The one named as the contract leader. Then you're also going to see, if you turn to the subscription agreement on any slip, you're going to see the expression bureau leader. And a bureau is not a fancy desk for this purpose. A bureau leader is the leader of one of the bureau. Bureau meaning shared processing systems. And in this market, the London market, there are three. There are three bureaus. The first is Lloyd's. The second is the Institute of London Underwriters, that I'm going to refer to as the ILU. And the third is the London International Insurance and Reinsurance Market. That would be LIRMA. So those are the three bureaux. And they are all serviced these days by Velenetic, who offer effectively the back office systems, the processing systems for each of those groups, what we call bureau. So that's what a bureau leader is. Okay. So I said we were going to talk about underwriting and claims separately. So let's kick off with the underwriting side. If you were to open an MRC, it's in 6 sections. In the middle, section 4, you're going to find the subscription agreement. And the clauses in there which deal with how underwriters will delegate authority to one another for the purpose of agreeing endorsements, because that's all they authorize one another to do, changes to the contract. These are the relevant clauses. They're not the ones from MRC 3.0, but they're the ones you most commonly see. And the most important of the clauses there, I've left blank just so I can fit in my arrow, because in this part, the basis of agreement to contract changes, we incorporate into every risk that's written in this market, almost, a reference to the General Underwriters Agreement, the GUA. Now, that is a separate legal document. If you go on the London Market Group website in the library section, you can find it. There's a link to it at the end of these slides. It's a whole document of its own that gets incorporated into every risk that it's written in this market. And it gives underwriters a roadmap for what can be agreed by way of endorsement on behalf of other insurers or reinsurers, other participants, and what can't. Now, if you turn to the General Underwriters Agreement, if you were to look it up, you'll find that there's some worthy pages at the beginning, which you may or may not feel like you need to read, but the guts fit are at the back, where you find a series of schedules. There are different schedules for different classes of business. And obviously, you need to refer to the one that's referred to in the MRC and the one that's relevant for your class of business. They haven't changed much over the years. Some of them have been in the same form since 2001. But they're all structured in the same way. And they all work in roughly the same way. So they're split into 3 parts. And each part lists types of underwriting decision in relation to an endorsement, which could be the subject of agreement by some constellation of the different parties. So part 1 lists out alterations the slip leader can agree on behalf of everyone else. And the sorts of things you see in part 1 would be restrictions in coverage, changes that decrease the monetary exposure. So you probably get the idea. These are things which, as a follower, you might not be too bothered with. But also, and the lists aren't exactly the same for each class of business, but you might find some things in there which are not merely administrative. So agreeing policy wording. That might involve some thought, but the lead might be authorized under that GUA schedule to do exactly that. So if you are presented with an endorsement as a lead and it falls within one of the categories listed in Part 1 in the relevant GUA schedule, you're okay to agree that on behalf of everybody. Part 2, in all of the GUA schedules, it's exactly the same. It's only got two things in it. It lists the changes, the types of endorsement that the slip leader and any agreement parties for contract changes, if they are all of one mind, if they are all unanimous, can agree on behalf of everybody. If they don't all agree, then the endorsement has to be agreed by all underwriters. And the things in that category are always twofold. Firstly, anything the slip says should be a Part 2 change. I think I've seen that maybe 2 or 3 times in 25 years, so it's not very common. But importantly, anything that doesn't fall within Part 1 or Part 3. So this is like a default bucket. A default bucket. If it's not in 1 or 3, it's in Part 2. And then Part 3, the final part, maybe the most important part, alterations which no underwriter authorizes another underwriter to agree on their behalf. Everyone's got to agree these sorts of endorsements. And the sorts of things that you find in the GUA schedule listed in Part 3 would be things like significant policy period extensions or changes to the jurisdiction that's relevant to coverage. And they all include, most important of all, the most important bullet on that slide, in my opinion, all alterations a slip leader or any agreement party for contract changes believes should be agreed by all underwriters. So the GUA has for a long time been an excellent roadmap, and it still is an excellent roadmap for underwriters faced with an endorsement. Who needs to agree the endorsement? But you can't cede all responsibility to the GUA. You can't leave your brain at home. You have to exercise some critical thought. And the rule to apply here, I would suggest, is the one that my mother, the late Reverend Schutte, used to talk to me about. Do as you would be done by, Andrew. Do as you would be done by. So, yeah, if you as a follower would want to see and agree the endorsement, send it round to everyone, would be my rule of thumb. So that's how the GUA works. And it's practically applied using, or used to be practically applied using this box, the GUA stamp or the GUA box. And so what you've got here, you can see box 1, slip leader only. So that's something that appears in Part 1 of the schedule. Box 2, slip leader and agreement parties for contract changes, if they all agree. And then all underwriters is box 3. And you also get, as the lead, to say whether everyone should be told about it and within how many working days, which is quite precise. So that's the bottom part of the box. Now, back in the day, that would be on every hard copy endorsement that was issued, but of course that's not the way that we work now. So I've got some anonymized screenshots which I can share with you. So this is PPL, and we're looking at the select parties dialog box, and it's not actually in the same order as the GUA stamp I see, but at the top you've got all agreement parties. So that would be your box 3. Next one down, all underwriters. Sorry, all agreement parties, that would be box 2. All underwriters, that would be box 3. Leader only, that would be box 1. So that's the equivalent in PPL. And if you're using white space, it actually does look pretty much like the GUA stamp. You've got 1, 2, and 3. Those grey boxes are just to anonymize it. So that's how it looks. Justin, are you ready to do some polling? Ladies and gentlemen, are you ready to do some polling? So I've explained to you how this works. So we're going to do a little thing here where we run a poll, and we're going to ask you to decide, just as you would do if you were presented with an endorsement. We're going to present you with a scenario, and then you've got to decide. Imagine you're the lead, being presented with this endorsement. Is it box 1? Is it box 2? Or is it box 3? Box 1, slip leader agrees for themselves. Box 2, slip leader and agreement parties. There we go. And box 3, all underwriters. So first one. I'd refer to the GUA non-marine schedule. Obviously, you don't have it, 233 of you. But just use your intuition, use your underwriting intuition, and just see what you think about this. So it's an endorsement which widens an existing war exclusion. So it excludes more perils. It is reducing the amount of cover that's on offer. What do you think? Is it slip leader only? Is it slip leader and agreement parties for contract changes, or is it all underwriters? So just have a go at that, and we'll see how you do. I don't know, Justin or Tom, how long do we give these guys?
I think just a moment or two more. Any final votes, please do place them. Perhaps we can see the results now.
Ooh. Well, it's a restriction in cover. So the 38% of you who said slip leader only, you're right. In the non-marine GUA schedule, it's 1.6. So you could, of course, have had it as one of those changes which a slip leader or any agreement party thinks should go to everybody under the do as you would be done by rule. But I would have thought that probably making an exclusion broader, more wide-ranging, is probably a pretty clear restriction in cover. So well done, the 38% of you who gave that a go. So should we go to the next question, Justin, please? Okay, so this is a non-cyber risk presented with an endorsement, and the endorsement is adding a little bit of first-party cyber cover. This is not a cyber risk, but it's adding in a little bit of first-party cyber. So maybe a bit of business interruption or something. Who needs to agree this? Is it the slip leader only? Is it the slip leader and agreement parties for contract changes, or is it all underwriters? Again, see if you can use your intuition and make a selection. We ready to get some results? Well, they're still coming in.
I think let's go for the results.
Yeah, let's do it. Yes. All right, now you're getting the idea. Yeah, I think it's all underwriters. I would say that this does fall within the do as you would be done by category. You're not writing cyber, but you're writing a bit of cyber. If it was increasing the total value at risk, actually under the non-marine GUA schedule, if the total value at risk goes up by more than 10%, then that's one to send round to everybody. But if you thought that it really was very incidental, perhaps it was a very small amount of cover being offered, and you didn't think that it fell within the do as you would be done by rule or the increase in the total value of risk by more than 10%, then you'd be on part two, actually, because it's not dealt with in part one or part three. So then you go to part two. And Justin, if we can have the final question, please. They're getting quite good at this now, so I'm hopeful for a strong result on this last one. Here we go. Who needs to agree an endorsement which changes all references to insurance now to read reinsurance? The broker says there's now a local front involved in the chain. So would that be 1, 2, or 3? Slip leader only, slip leader and agreement parties, or everybody? Do we get some results? Ready for results? Slip leader and agreement parties for contract changes, if unanimous, was the most popular with 49%. 16% of you said slip leader only, 35% of you all underwriters. That question, which I've done many times over the years, I think that the do as you would be done by rule would probably apply there. I think many underwriters would want to know that there was a front involved and they were no longer providing direct insurance. But there could be particular reasons why you don't feel that way. Maybe you already knew that that was on the cards and you were happy with it and you'd seen the fronting agreement. In which case, 49% of you would have been right. It would be part B. It's not listed within part 1, so it wouldn't be slip leader only. Great. Well done. You get the idea, and I guess the message that I want to get out from that little exercise is it's really important to know your own GUA schedule as an underwriter. It's really important. If you haven't looked at it before, I recommend that you take a look. Okay, so that's how it works when it comes to claims. There is no delegation of authority by any followers to a leader for underwriting the original risk. It's only on endorsements. And when the endorsement comes in, you have to normally select who has to agree it, and the GUA schedule is your guide. That's underwriting. Claims. So also in the subscription agreement, but slightly different clauses, we see how claims are going to be dealt with. And I put up on the screen, again, not the MRC 3.0 version, but the version I most commonly see, of the basis of claims agreement. So you can see the clause there on the top right, and I've done a little chart for you, which we're going to walk through step by step to just show you how this works. We can actually summarize it quite quickly because it's not that hard. I'm quite sure what our graphics department have done there. I can only apologize for that. Anyway, it's not a kidney. I don't know. Yeah, so for Lloyd's, if you were participating through Lloyd's, obviously not this audience, but the Lloyd's claims lead arrangements would apply. And what they mean is that claims get agreed by the Lloyd's lead. And for qualifying claims above a certain value, normally the second Lloyd's lead. And they bind all the other Lloyd's followers. That's how that works. The IUA Claims Agreement Practices 2025 does not change the fundamental workings of the existing IUA claims agreement practices. I'm proud to say I was associated with drafting the new document. It's much clearer to read than the old one. I mean, I know I would say that, but that was the object, and hopefully that's what we've achieved. So no actual substantive change, save for one little one I'm going to point out later. But the way those work, as they've always worked, is that if you were participating through a LIRMA stamp, so you're part of the LIRMA Bureau, you get to be an agreement party for your own share of any claim. If you were using an ILU stamp and participating through the ILU Bureau, then you would follow the claims agreement of the ILU lead, unless you were the lead. And in some circumstances, there needs to be an ILU second lead, or there may be an ILU second lead. So other ILU stamp companies, they would follow those two, but they have the option to object to any claim settlement within set timeframes. And I'm going to unpack all of that in more detail in a minute. But that's basically how it works. That slide there, you can leave the kidney out of it maybe, but that's all you need to know. So going through all of this in a bit more detail, let's start with the single claims agreement party regime, or SCAP, because that's one way in which the subscription market deals with a certain type of claim. In order for this regime to operate, the lead has got to be a UK authorised insurer or Lloyd's syndicate. And you effect SCAP, you incorporate SCAP into your contract just by including LMA 9150 into the subscription agreement. And actually the pro forma version that you'll see on the London Market Group website has for some time, at least the last 2 iterations, included LMA 9150 as standard. So if someone was using that as the basis, it would be in. You'd actually have to make a conscious decision to delete it if you were using the template that's up on the website. And this is the paragraph that does the business. So if it's a claim within the SCAP clause, the slip leader agrees it on behalf of everybody else. So, big question, what are those claims? What claims are in scope for SCAP? It's basically claims up to $250,000, claims or circs valued at up to $250,000 to the slip. So if you had a risk that was placed on more than one slip, then you would have to take your share. If you, all you can see is 40% of the risk, it'd have to be $250,000 to that 40%. It also means that you could have, exceptionally rare, but you could have an excess layer that's only just getting impacted, and that could potentially, if you had a SCAP clause in your excess layer, it could mean that that was a SCAP claim, but that's not common. So it's $250,000, but with some exceptions. Basically, if it's a hot potato claim of some sort, and any of these things apply, it wouldn't fall within SCAP. So it has to be blunt about it, a pretty straightforward claim worth up to $250,000. You can reassign claims once they are in flight, as they say in the guidance. And the contract leader or the broker can do that. So if it started out being controversial and then it stopped being controversial and it was low value, we could flip back into SCAP. Or you could have a SCAP claim that then becomes worth a bit more, for example, and then it would flip out. And it's the leader or the broker who can reassign those claims. So if you were a lead, you get a SCAP claim in, what have you got to do? You've got to assess whether it actually is a claim that's in scope, and then you've got to do some notifying. You've got to notify the broker, you've got to notify the claims agreement parties. Who are the claims agreement parties? Well, you have to look at the other bits of the claim section of the subscription agreement, which we're going to come to in a minute. Once you've done that notification, you've got to determine the claim, doing all of the things that you can see on the screen. And I quite like this list. I like this list because I think it spells out what a leader's duties to the followers on claims probably are under the common law anyway. But it's actually gone to the trouble in the SCAP clause of spelling out what all of those things are. So useful checklist there. And if you want to, as a lead, you can instruct the lawyers, you can instruct the loss adjusters yourself and not trouble anyone else. It's up to you. Now, there's also some provision in the SCAP clause for brokers to have some things to do, which is a little curious because the brokers are not parties to this insurance contract. So how does that work? Discuss. Undecided is the response. But anyway, the broker is said to have the duties you can see on the screen. So they've got to tell the claims agreement parties of all of the things that you can see there. So that is a job of work for them. And the followers, which is everyone apart from the lead in this case, can ask the lead or the broker for any information they reasonably require. And both the lead and the broker have got an obligation to cooperate fully. Again, quite like that because it sets out in terms what is probably the case under the common law anyway, in respect to the lead. I'm not sure whether the broker necessarily would agree that they have an obligation like that implied under law, but we could have an interesting argument or debate about that. It's possible. Under SCAP, they've also catered expressly for a scenario where, let's say you're a follower, you might not be happy with the way the lead is dealing with things. If you have claims concerns, there's a way of dealing with it. You notify the lead, so speak up, the first thing. Secondly, you need to speak to them and use best effort and endeavors, to resolve. Next thing. If you still can't agree, after 28 days, you're done. The lead's authority disappears. So it's actually quite straightforward to nix the leader's authority when it comes to the authority they're given under SCAP. It's quite straightforward, really. And if you did not like what the lead had done and you felt that you had suffered loss, there was going to be a dust up, a little bit like what was just about to happen at the point this photo was taken. You'd go to the dispute resolution procedure, and as with most intra-market matters, they try to bore you to death before you actually go to any sort of hearing. So you have to make a good faith effort to resolve. That doesn't work, you've got to mediate, and only then could you go to fast track arbitration. I've not seen one of those yet. There is also a liability cap for SCAP leads. They can only be liable for up to £500,000. And you'll remember that SCAP claims can only be worth £250,000. So we're talking about reasonably minor exposures, unless, of course, there are multiple claims. If a whole book of business has been poorly dealt with, you could still be looking at a big number. So that's how SCAP works. And anecdotally, the biggest problem in practice is people realizing that they have a SCAP clause written into their contract and actioning it. But it's a pretty thorough piece of drafting, and the clause gives you a roadmap again of how you should deal with it. If you had a claim that didn't fall within SCAP, or you didn't have a SCAP clause at all, then you would be looking at the rest of my little diagram here, which I have circled in red. So you'd be looking at those things, and we're going to explain how all of that works in a bit more detail now. So if you're a Lloyd's syndicate, you'd go via the Lloyd's claims lead arrangements, which I'm not going to dwell on for this audience. If you were a company's market participant, then you would be using the IUA Claims Agreement Practices 2025, new and improved from a readability perspective, not from a content perspective particularly. Now, those claims agreement practices apply to any user of LIRMA or the ILU. So all that's needed is you need a LIRMA or ILU stamp from Velinetic. You don't actually need to be an IUA member. If you're not an IUA member, you might want to speak to Tom and sign up, but that's a different question. You don't need to be paying your subs to the IUA in order for the IUA claims agreement practices to apply. You just need one of those stamps. It's also not mandatory. You can contract out. You're allowed to agree whatever regime you choose. This is a market, but there is a practical consequence there, because Velinetic is set up to deal with claims using the IUA claims agreement practices. So if you use a LIRMA or an ILU stamp and you don't want the IUA claims agreement practices to apply, you might find your back office processing the claims system doesn't really meet your needs. And that might mean you need to speak to Velinetic. And I don't know, I have no way of knowing, but I'm guessing that if you were asking them to bespoke stuff for you for a particular risk or series of risks, that could be an expensive conversation. I don't know. So you could consider, if you have this option, if you have it available within your organization, to use a stamp that is actually non-bureau, if that's what you want to do. But you can contract out. There's no reason you need to use it. So that's how it works for Lloyd's. That's how it works for LIRMA and ILU stamps. But of course, we do have people participating in risks in this market who don't fall into either of those camps. And for them, the standard form MRC subscription agreement says that the practices of any insurer or reinsurer electing to agree claims for their own share will apply as the basis for claims agreement. What does that mean? Again, undecided. But it probably simply has the effect that anyone who's participating outside the bureau gets to agree claims for their own share. Oh yeah, thousands of these on my phone, thousands. Yeah, under the MRC wording, the usual wording, who gets to agree claims? This is really what we need to know. So for sure, the lead, obviously. As we've discussed, the Lloyd's lead and any Lloyd's second lead, so for high value or complex claims, they get a second lead. Anyone who's participating through LIRMA, they get to agree claims for their own share. An ILU lead, and if there is any second lead required, they get to agree claims for their own share, as do anyone who objects to an ILU lead's settlement within the time frame that we're going to come to in a second. Anyone participating outside one of the bureau, which we've just been discussing, they probably get to agree claims for their own share. And then the standard wording also says anyone on ex gratia settlements gets to agree for their own share. So that is your list of the runners and riders in a market meeting who ought to have the ability to decide their own fate under the usual wording. But the wording does sometimes get amended, so you need to be careful. So I've talked about second leads a little bit. When would that come up in the companies market? So for the ILU, this is the one thing that changed when we issued the 2025 IUA Claims Agreement Practices. Now the rules say expressly for marine claims, if there's no one else participating who's using a Lloyd's stamp or a Lerma stamp, then you have to appoint, if there is one, another ILU participant as a second lead. It doesn't say who, it doesn't give any criteria, but you have to, if there is another ILU stamp company on the slip, you've got to appoint them. And if there's more than one, you get a choice. In all other circumstances, it's entirely up to you whether you choose to have an ILU second lead. And I guess the question for you would be, would it be useful? And if so, go ahead and appoint. And if not, you don't have to. The Lerma, we don't need to worry about this. There is no such thing as a Lerma second lead. They do not exist. So that's how it should work for claims. We can complicate things a bit in this session today. I'm not going to overcomplicate. There's quite a few ways in which it could get more complicated, but I have to mention this one, multiple slips. So it's not infrequent in this market that the same risk will get placed on more than one slip. And how might that look? Well, normally it would mean that you've got the same subject matter insured or reinsured, you've got the same limits. You might or might not be on exactly the same terms. And the placement might be called different things. Various phrases in the market that get used to describe a placement across more than one slip. Vertical placement, probably most commonly used where the broker's intending to allow different people to set different prices, but it can be used in all sorts of scenarios. It's not got a legal definition, and nor has off-slip. So off-slip, I think, normally means most of the insurers or reinsurers are on one slip and you're on a slightly different slip, probably slightly different terms, and there's fewer people on there. But that doesn't always apply either. Sometimes you find that over the years, the off-slip has actually got more participants on it than the regular slip. So just some caution is needed with these terms. And leading your own slip equally. So this is normally used where, let's say you were going to be a Lloyd's follower. You'd have to agree on claims, but you don't want to do that. You want to agree everything for your own share. So you might say, well, I want to lead my own slip, and then I'm shown as the contract lead. But the consequence of these multiple slip placements is if you go on the system, you can't see 100% of the participating insurers. You can only see the 20% or the 40% or whatever it is that's on your slip. It might just be you. And as I say, reasonably common, and it creates some questions when it comes to leaders and followers. We always want to know, and we don't know because you get on the system, you can't see it, who's on the risk. See the people on your slip, no one else. Who is being treated as the lead? Is somebody being regarded as the lead? Maybe they've got a big participation all the way up the program, and or maybe they're just got the biggest share. Who knows? But is there somebody you're not aware of is being treated as the lead? And the converse, have you got followers that you don't know about, perhaps? Who are the followers? You can't tell because you can't see the full picture. Sometimes you'll get the question, oh, well, are the slip wordings consistent. And there you might have to go back to what we were talking about with the endorsements. Who's bound whom? Has it all been properly done? And if the slip wordings aren't consistent, is there a way to reconcile all of those things, or is that actually following through the party's intentions? These are quite tricky questions at times, and they come up pretty much every time we get a multiple slip file on our desks as lawyers. So we spend quite a lot of time on multiple slips. I'm not going to say much more, but hopefully you got the idea. They complicate things a bit. So I've run through how it works for underwriters and claims, and now I'm just going to talk about sort of picture more holistically. And I'm going to look at it, first of all, from the position of the followers and then the leaders. So if a follower calls me up and wants advice on these issues, they may have a lot of different questions, but they normally boil down to, on the claim side anyway, do I have to follow? I'm not happy with what the lead's doing. Do I have to follow? And well, you guys will be experts at this now, because the answer will be in the subscription agreement, almost certainly. You need to look at the placement as a whole. So you can have some contradictory terms floating around. There might be a claims protocol, for example, that's been agreed that might cut across the subscription agreement. You might find that the subscription agreement in any delegated authority agreement, which is applicable to the risk, which is the way the risk has been written, that might clash. So you need to look at the whole thing. But the subscription agreement is where you should find the answer. If there are multiple slips, it can be complicated. And often a follower will say, well, looks like an ex gratia settlement, so I don't have to follow, which strictly is right. But a cautionary note about that, it's not always easy to prove that something is indeed an ex gratia settlement rather than a commercial compromise, which is what they are more commonly called. So just, it's not a get out of jail free card, that ex gratia settlement one. In Lloyd's, commutations and rescissions also apply, but that's only within the Lloyd's claim scheme. If you were participating through the ILU, then as a follower, knowing your rights, what has the lead got to do for you? Well, they've got to manage the claim. They've got to raise queries and information requests with the broker. They've got to agree or dispute the claim advices. And if there's a second lead, they have to do that unanimously together. If you don't agree with a settlement, you may object, as I've referred to a couple of times, and you have to do it within a set period. So I've done this talk a few times since we put in the new rules, and this has come up a lot, so I'm going to give you a sort of cut out and keep guide. So the time runs from the first minute of the working day after the signing reference for the claim settlement gets allocated. It only elapses over working days. If you operate a 3-day rolling settlement, then you get 2 working days to object. No questions, please, on exactly what that means, because this lawyer is not entirely sure what a 3-day rolling settlement is, but hopefully you'd recognize it if you saw it. Otherwise, that's the table that applies. So we've got different periods for aviation, marine, excess of loss and incidental non-marine claims. I must say it's some years since I've come across that expression before looking at this, incidental non-marine claims. And then any other line of business, 2 working days. So it's quite a short period to object if you didn't like what the lead was proposing to do. So that's your objection period right there. If you were participating through LIRMA and you were a follower, so that you had a LIRMA bureau lead, then what must your lead do? It's got to raise queries and information requests with the broker. It's got to circulate claims advices to the followers once it's happy with the information the broker sent round. And it's got to tell the broker about any requests that you or any other follower might make for more information. But they're really more of a post box because they do not bind the LIRMA followers. And as a LIRMA follower, you are responsible for looking at the information that you get and requesting more information. So it's a much more restrictive role. There is also in the rules a provision for LIRMA participants to put a stop on your participation. Have a look at clause 3.6. So that basically is it's a lock on any claims advices or settlements going through for your share. So what could you do if you were a follower and you felt like you didn't have many rights in this sort of situation? This comes up most commonly with Lloyd's followers. But what can you do? A lot of it is soft power and just speaking up, actually. The first thing, get the mud map if you can. In other words, get the security list. See if you can find out who else is on the risk. It's very different being a lone voice in the wilderness to speaking together with some other of your peers on a point that's concerning you. So do find out who else is on the risk. You've learned in this session about your rights to information. You have the right to ask the lead for copies of reports and things, and they ought to give that to you. But most importantly, be vocal. Raise concerns with the leaders. We often find that the guiding mind in a market meeting is not necessarily the person with the biggest share. If you want an illustration of how all of that works, the Traitors is on TV right now. I'm not saying that claims handlers are traitorous, but you see how people are guided by others. It's Judy. You're going to get rid of Judy. Oh, good idea. Yeah, Judy. She's a thing. Those of you who have seen it will know what I'm talking about. So be vocal, raise your concerns. You might find that you have quite a lot of influence. Let's say, however, having dealt with the follower scenario, you were a lead and you called me up. What would you likely be asking me? You'd probably be asking me on the claims side again, could the followers sue me if they don't like what's going on? And in my advice to you, I might say, well, it may turn in part on whether there's a contract of agency here. Are you, as the lead, the agent of the followers? And that's important because if you are, you owe them a fiduciary duty, which is the highest duty known to English law. And actually, there's quite a lot of case law. The majority of the case law says, yes, the leader is the agent of the followers. There are a couple of cases that point the other way. Mandarin Commercial Union sort of sits out on its own. Mr. Justice Ricks, as he then was, took an approach to leaders and followers that's never been followed since. I won't bore you with the detail, but it sort of sits out on its own. And St. Evans Maritime, which we're going to come back to in a minute, that was just a bit of what we call obiter dicta, just a passing comment, really. But they suggest that maybe the leader's not the agent of the followers. And then we got this very curious decision by Mr. Justice Jacobs about underwriting. It's hard to know whether that would have any effect, but arguably, if you were to agree an endorsement on a scrap piece of paper, that wouldn't make you the agent of the followers. It's a weird decision. Again, don't really have time to go into the ins and outs of it, but it's worth a read, actually. So what duties does the lead owe then, Andrew? You're reading on in your advice. Well, anything that's actually expressly set out there. So if there were a claims protocol, perhaps trying to vary the subscription agreement, you'd have to look at that, provided it was validly incorporated into the contract, which is not a given. You'd look at the Lloyd's Claims Lead arrangements. You'd look at the IUA Claims Agreement Practices 2025. And probably, regardless of all of those things, either there'd be a fiduciary duty or a duty in tort for you to act in good faith, avoid any conflict of interest, not make secret commissions, carry out follows instructions with reasonable care and skill. I would suggest that your touchstone as the lead would always be to try to act in the best interests of the followers. If you do that, you will be on the right side of the somewhat uncertain law. That will always be right. And those duties are owed on underwriting and claims. So that's how things stand if you are the lead. What happens if the followers are not happy with you and you are looking at people saying, well, you owe us money? That does happen occasionally. And I've been involved in many of those cases over the years. Is there a limit to the lead's liability? Within Lloyd's, just within Lloyd's, so not actually relevant to this audience strictly, there are some limits, and there they are. They only apply if people aren't fraudsters. The one that does apply to you guys would be the SCAP limit. We talked about already, $500,000 limit per claim. But there is no implied liability limit for a company market lead. So your exposure to the followers, if they were to say that you breached your duty to them, and the normal way this comes up is you settle for a higher figure than they're happy with, there is no limit to your liability. So it is potentially a scary place to be. Coming towards the end now, What would happen then in that situation? Let's say that you wanted to settle for 20 million. The following market, you're the lead. The following market say, no, I think it should be 10. And the way the subscription agreement works is you do bind some of them. So you're in a bit of a tricky position. Maybe you have a conflict of interest because you want to do something for yourself, which is not in the best interest of the other insurers. How would you deal with it? Well, the first question is the subscription agreement really contractually binding, or is it just administrative? This is often raised, but I think it's quite clear that it is contractually binding. And actually, the MRC guidance has for some time confirmed that itself. So I think it's going to be hard to say that it is merely administrative. And the Lloyd's Claims Lead Arrangements and the IUA Claims Agreement Practices do both say what you should do where there is a conflict of interest between you as the lead and the followers on a claim. You should step aside as lead. I don't have time to poll how many people have seen that, but I'm guessing it's not going to be very many because it's quite rare. Very rare, in fact. There is a workaround that sometimes used, sometimes attempted, which is a settlement which is expressed not to bind the following market. And I want to leave you today with a sort of cautionary tale, really, which is about exactly that. So that is the San Emmons Maritime and Aegean case. Apologies if that's a mispronunciation, it probably is. Anyway, this was a multiple slips case. 2 slips. The first slip was placed in London. So you see here some London market gentlemen indulging in one of their traditional pastimes, and they wrote this risk 50%. And as is most commonly the case with multiple slip placements, their slip made no mention of any other slip. It just stood on its own. They were not aware that anyone else was involved. But there was someone else involved. It was Aegean, who are a Greek outfit, and they took 30% of the risk on a separate slip. And their slip was different. Unusually, it actually did refer to the other placement. And it said that Aegean agreed to follow the London insurers in claims. So 2 slips. Now, what happened in this case was pretty much what always happens. A claim comes in, and the London insurers did a deal, which they were happy with. They were happy with it, but Aegean were not. So the lawyers who were acting for all of the market tried to get around this by drawing up a settlement agreement. The settlement agreement was just for the London insurers, and it expressly settled the claim for their share on the basis that it was not done in the capacity of a leading underwriter, and it didn't bind any other insurer. And that's what was signed. Now, once the ink was dry on that settlement agreement, Aegean took it down to the commercial court in London, and they shoved it under the nose of Mr. Justice Tier, and they said to him, you don't need to know anything about this claim. The facts are completely unimportant. All you need to know is that Aegean agreed to follow London insurers in claims, and the London insurers have settled. So the policyholder said to Mr. Justice Tier, you've just got to make Aegean pay. That's all you've got to do. Just enforce the terms of their contract. So Mr. Justice Tier had a choice. He could either agree with the policyholder and enforce that follow provision you see in the middle box, or he could uphold the settlement agreement that had been drafted by the insurer's lawyers. He went with the slip. So Aegean had to follow the London insurers. And it was appealed, but they never made it to a hearing. So that's the way the case landed. So that's tricky. And it highlights the difficulty of settling just for your own share. If that's what you plan to do, I'm here for you because I think you need some legal advice. And Tom, I'm nearly there. I'm just summarizing what's going on. So subscription agreement, reflect your intentions, know your schedule, multiple slips are tricky, followers' obligations, turn on the wording, watch out for conflicts. Our claims agreement practices for the IUA are now clearer. You might be liable to followers as a lead for breach of duty. And most important lesson for you all, phones live on a high shelf. That's the only way I've managed to stop the flood of selfies. If anyone else has a better way of stopping the selfies, please let me know. And now we've got just 3 minutes maybe for some questions.
Yes, thank you very much, Andrew. And obviously, a huge amount of information to get through in the time that we had. And thanks for entertaining us along the way with the selfies of that your children have taken on your phone, which very amusing. So yes, we have a couple of questions. We'll need to move through them relatively swiftly. One question that cropped up, is the lead's liability to followers on a per follower basis, or is the limit of liability for the entire following market?
Well, each follower would have potentially a claim against the lead for their loss. So it would be, you can't have more loss than your share. So it would be sort of on a per follower basis. But the caps are per claim. So the way the Lloyd's cap works is there's 5 million there per claim, but it gets shared out between all the followers. So if it was let's say it was an energy claim and a rather large amount of money was changing hands, then that 5 million has to be shared out between everyone. And it's the same for the 500,000 on the scat clause, although of course there the claim isn't going to be more than $250,000 in the first place. So you're likely to get your full indemnity if you were to make it stick. But there are no reported cases of any of these disputes that are going to court, because I can tell you that they almost always settle. And the only way that they would be resolved if they didn't settle would be through arbitration in almost every case. And that's confidential, obviously, in this jurisdiction.
Thanks, Andrew. And speaking about claims that can arise between the parties, a question relating to if we had an error from a broking representative. Obviously, they have a very important role to play in both claims and underwriting, but focusing here on the GUA and changes to the contract. Have you seen examples of broker E&Os arising out of use or misuse of the GUA?
Yes.
Okay.
It's a tricky one, and this is an untested area. So often, if the GUA box has not been properly filled in, and that has a financial consequence, the first thing that the broker will say is, well, it's the leads filling that in that field, and so they need to get it right. And the first thing the lead is going to say is, well, the broker came to me and told me to put my tick in box 1 to say that it was slip leader only. And I do have a view on how all of that should work out, but there's no case law on it, and it can be tricky depending on the facts. So it's worth highlighting. But yes, it is the case that a policyholder who is trusting the broker to get that endorsement over the line has got a claim over against the broker if the broker fails, for example, to get that policy extension because they should have got everyone's agreement and only got the leads. And then the followers will say, well, actually, I'm only bound to the previous period. That does happen.
That's helpful. Thanks, Andrew. And just a very brief response to this one. What determines the MRC version to be used?
It's a matter of contract, really. The guidance is that we should all be using MRC 3.0. We should have been doing that for over a year, but it's quite a big, chunky document, and it doesn't seem to be super popular. So as a lawyer, leaving outside, I'm not sure. I don't think that Lloyd's have mandated the use of MRC 3.0. In this audience, the IUA doesn't tell you what to do. It just helps you out. So it's really a question of horses for courses, but the brokers haven't all taken it up, and I think that is why it's not being used. But they all work as contracts. It's just a question of not preference exactly, but how much you're going to heed the guidance.
Indeed. Thank you, Andrew. And we did have one other question. It's just relating to the decision between choosing a LERMA or an ILU stamp and the differences between them. And really, it does all come down to those claims agreement parties and whether you essentially want to have that decision with your for your own share within the LERMA world or in the ILU world to have the possibility of being led by another party. So that was just one other question that came up. But I think we need to leave it there just with an eye on the time. So Andrew, a huge thanks from me for the time that you've given us today and the excellent presentation. Obviously, thank you to everyone who dialed in and for getting involved in the interactive polls along the way. We will be circulating the slides as we mentioned and posting a recording of this session on the IUA's YouTube channel. There are some specific sessions in there actually covering SCAP and the IUA's claims agreement practice, so some other material if you are interested. And of course, look out for our upcoming sessions in this Underwriting Essentials series, which I'm sure will feature more of Andrew and perhaps some of those selfies along the way. So thank you all very much and enjoy.